Hi everyone, my name is Isabella, and today I would like to discuss with you the importance of establishing effective shareholder management structures during the early stages of your startup. Firstly, I would like to discuss what shareholder management is and why it should be thought of early. Secondly, I will discuss what a shareholder agreement is. And finally, I would like to go through a few provisions commonly included in shareholder agreements and why they are important. What is shareholder management, and why is it important to set up earlier rather than later? Shareholder management is about managing your shareholders in a way that facilitates the growth of the business. There are many ways to manage your shareholders, their rights and interests, as well as your own. A few include having a well thought out shareholder agreement, having a detailed company constitution, and following basic safeguards set out in the Corporations Act. For the purpose of this presentation, I will be focusing on shareholder agreements. The best time to set up your shareholder management structures are during the early stages of your business. This ensures that all of the parties are still enthusiastic, and it is unlikely there have been any disputes or disagreements over the running of the business. Setting an agreement up early ensures that both investors and entrepreneurs have a common understanding of what exactly they expect to give to the business and what they expect from the business in return. If there is any difficulty in reaching an agreement during this early stage, then it is an ideal time to consider the future of the relationship. The later an agreement is made, the further an investor's expectations may disunite from the expectations and goals of the company. This can make reaching an agreement at a later stage very difficult. What is a shareholder agreement? A shareholder agreement, also known as a founder's agreement or a shareholder's contract, sets the terms to regulate the rights and obligations of members in a business, in addition to regulating various aspects of the management of the business. For shareholders, it ensures you are treated fairly by clearly outlining your rights and obligations. For businesses, it describes how the company will be run and how important decisions relating to the company will be made. A shareholder agreement also sets the terms for interaction between members, including shareholders, directors, and founders. An effective shareholder agreement will be designed to deal with issues that can arise throughout the life of the business by determining in advance how those issues will be dealt with. To be effective, your agreement should be drafted clearly and should work to resolve issues quickly with certainty and finality. How you develop your shareholder agreement and what you include in it will differ between entities and depends on the discussions and input of your shareholders and their advisors. Remember, a shareholder agreement is not a one-size-fits-all document. Although there may be many similarities between agreements, to be most effective, it needs to be relevant to you and your shareholders. The biggest mistake a company can make is not being involved in the development of their agreement or using a generic template. Shareholder agreement enforceability. A shareholder agreement is a legally enforceable contract when drafted correctly. The rules around its enforceability and remedies that may be available if a breach occurs follow the standard practice of contract law. To be legally binding, the parties must all agree to all the terms of the agreement. The parties must have the intention to create legal relations between them, and shares must be given in exchange for a party's promise to abide by the agreement. A shareholder agreement applies in addition to rules contained within your company constitution and the Corporations Act. The Corporations Act sets basic safeguards in the form of replaceable rules, which apply to all companies registered after the 1st of July in 1998. Majority of these replaceable rules can be modified or replaced by your company constitution, except for a few mandatory rules regarding minority shareholders. Your company constitution and the safeguards set out in the Corporations Act may not be enough by themselves to fully protect you and your shareholders in the event of a dispute. It should be noted that a shareholder agreement can and usually will overrule your company constitution. Therefore, having a shareholder agreement that is unique to your company is vital in protecting the interests of you and your shareholders. Common provisions. A few common provisions you may want to include in your shareholder agreement include admitting and terminating directors and shareholders, director and principal shareholder duties, deadlocks and disputes, delegating decision-making to individuals or committees, and competition restrictions. Admitting and terminating directors and shareholders. Typically, this provision sets out how persons can join or leave a company, and whether or not these decisions need to be made unanimously or by majority votes. The provision may also set the minimum and maximum number of directors, and how they are to be appointed. For example, you may decide that only shareholders with a certain percentage of shares can appoint directors, or it may be preferred that only founders hold that right. The provision should also set how and when directors can be removed. For example, if a director was to become incapable of managing their affairs due to a medical condition. This provision may also include a simple solution to preventing deadlocks, which many companies employ. That is, to never have an even amount of directors at the one time, therefore removing the possibility of a tie. Director and principal shareholder duties. The Corporations Act sets out a range of director duties, including to represent the interests of shareholders, to avoid conflicts of interest, to carry out their work with due diligence and care, to not use their position or information obtained from their position for personal gain, and to not cause detriment to the company. In addition to these duties, this provision may set out specific roles and responsibilities assigned to individual shareholders or directors for each to carry out on behalf of the company. These specific roles could include marketing activities or hiring and employing new staff. Other matters covered by this provision may include productivity levels expected from each member. It may also include whether permission needs to be given by all shareholders and directors before a member can take a position on an external board. This is important to cover due to the potential impact on the company and the need to disclose any potential conflicts of interest. It is important that duties set out in this provision are unambiguous to ensure that all members have a clear understanding of what is expected from them and to prevent disputes. Deadlocks and dispute resolution. This provision should set out how to resolve disputes, including how to resolve deadlocks between shareholders and directors, and how to resolve disputes when shareholders can't agree on the management of the company. Generally, these disputes can be resolved by an agreement of the parties. However, occasionally issues will arise which cannot be decided or resolved informally. This is where it becomes important for your shareholder agreement to include alternative dispute resolution processes, such as arbitration, mediation, or conciliation. It should be noted that including a provision to resolve disputes using an alternative process cannot replace the jurisdiction of the courts. However, when carefully drafted, you can set court hearings as a last resort. Delegating decisions to individuals or committees. If you plan on delegating decision-making powers, a shareholder agreement is a great place to specify the extent and limitations of each individual shareholder's power and authority, as well as the authority of the board of directors. It is very important that this provision be clear and expressly formalized, as disputes regarding authority are common when delegations are unclear or are uncertain. Competition restrictions. Many companies like to include competition restrictions into their shareholder agreements. These restrictions prevent shareholders from competing with the business, whether they are moving to a new company or starting their own company. This provision should specifically cover a number of relevant areas, including engagement of staff and access to resources, such as files, client lists, and premises. A competition restriction also usually sets a geographical area to prevent the shareholder from working with a competitor firm in the same area. This provision protects both the company and the interests of your other shareholders. To give you a better understanding of how these provisions fit into a real-world document, I've taken a few extracts from a generic shareholder agreement template. As you will see, the first page outlines who is bound to the agreement and clearly states the purpose of having the agreement in place. The second page includes articles for the management and control of the business. This includes director appointments and duties. The third extract details competition restrictions, and the fourth sets out dispute resolution processes. Now that we have reached the end of my presentation, I hope I have left you with a clearer understanding of why you should think about shareholder management in the early stages of your startup and why you should set up a shareholder agreement to best protect you and your shareholders' interests. Thank you.